Philippine Immigration Act. Foreigners' entry and admittance to the Philippines is a privilege because each state has absolute and exclusive sovereignty over its own territory, as well as the right to administer it. All foreigners permitted to the Philippine territory are bound by the territory's law and owe a local or temporary loyalty to the Philippine government. They are obligated to follow Philippine laws and may face legal action if they do not. When correctly enforced, they may be required to share in the general public burden. Due to the public interest in policing its territory and ensuring the orderly admission of aliens into the country, the Philippine government has decided to enact a general rule that will ensure appropriate screening for those seeking entrance. It was also thought important to establish processes and protection for foreigners entering Philippine territory. On May 2, 1940, the Philippine Assembly passed the Philippine Immigration Acts of 1940, also known as Commonwealth Act No. 613, or it is commonly known as an act to control and regulate the immigration of aliens into the Philippines. This law, along with its revision, governs foreigners' entry and admission into the Philippines, and it was signed by former President Manuel L. Quezon on May 26, 1940. For non-immigrants under Section 9, aliens departed from any places outside the Philippines who are otherwise admissible and who qualify within one of the following categories may be admitted to the immigrants: a temporary visitor coming for business or for pleasure or for reason of health, a person in transit to a destination outside the Philippines, and a seaman serving as such on a vessel arriving at a port of the Philippines and seeking to enter temporarily and solely in the pursuit of his calling as a seaman. Documents for non-immigrants. Under Section 10, presentation of an expected passport. Non-immigrants must present for admission into the Philippines an expired passport or official document in the nature of passports issued by the governments of the countries to which they owe allegiance, or other travel documents showing their origin and identity as prescribed by regulations, and valid passport visas granted to diplomatic or consular officers, except such documents shall not be required of the following aliens. First, a child qualifying as a non-immigrant born subsequent to the issuance of the passport visa of an accompanying parent, the visa not having expired, and a seaman qualifying as such under Section 9 of this Act. Under Section 11, the form and manner of applying for a passport visa and the form of validity of such passport visa shall be established by regulations. Then under Section 12, a passport visa shall not be granted to an applicant who fails to establish satisfactory his immigrant status or whose entry in the Philippines would be contrary to the public safety. Legalization of residence of aliens. Section 41. Any alien in the Philippines at the time of the passage of this Act, concerning whom no record of admission for permanent residence exists or can be located, may apply to the Commissioner of Immigration for legalization of his residence in the Philippines. The application shall be made in the form and manner prescribed by regulations issued by the Commissioner. Any alien in the Philippines whose record of admission for permanent residence does not exist or cannot be located, and who shall fail to legalize his residence in the Philippines as provided of this section, shall be presumed to be unlawfully within the Philippines. If the Commissioner of Immigration finds that the applicant, first, entered in the Philippines prior to the effective date of this Act, second, has maintained a residence in the Philippines since he entered, third, is a person of good moral character, and is not subject to deportation, the Commissioner shall make a record in the Bureau of Immigration that the applicant's residence in the Philippines has been legalized. And if an alien whose residence has been legalized in accordance with the provisions of this section shall be deemed to have been lawfully admitted into the Philippines as of the day of his entry. Special provisions. Section 47. Notwithstanding the provisions of this act, the President is authorized, when the public interest warrants, first, to waive the documentary requirements for any class of non-immigrants under such condition as he may impose. Second, to admit as non-immigrants alien not otherwise provided for by this act, who are coming for temporary period only, under such condition as he may prescribe. Third, to waive the passport requirement for immigrants under such condition as he may prescribe. Fourth, to reduce or to abolish the passport visa fees in the case of any class of non-immigrants who are nationals of countries which grant similar concessions to Philippine citizens of a similar class visiting such countries. And fifth, to suspend the entry of alien into the Philippines from any country in which cholera or other infectious or contagious disease is prevalent. Visa Policy of the Philippines. The Philippine Immigration Act, also known as the Commonwealth Act No. 613, and subsequent legislation revising it govern the country's visa policies. The Department of Foreign Affairs and the Bureau of Immigration jointly enforce the act. Visa-free entry is available to visitors from 157 countries for periods ranging from 14 to 59 days. Generally, foreign nationals who wish to enter the Philippines requires a visa unless, first, if he or she is a citizen of a member state of Association of Southeast Asian Nation or ASEAN. Second, if he or she is a citizen of a non-ASEAN member state whose nationals are allowed to enter the Philippines visa-free. And third, if he or she is a balikbayan and is only returning to the Philippines temporarily. Under Executive Order No. 408, signed by President Carlos P. Garcia on November 9, 1960, and subsequent executive issuance amending it, govern the Philippine Visa Waiver Program. While the Bureau of Immigration issues visas, the program is managed by the Department of Foreign Affairs, which maintains a list of countries that are eligible to participate. In principle, nationals of countries with whom the Philippines maintains diplomatic relations and whose citizens are not designated as restricted by the DFA are entitled to enter the Philippines without a visa. Those who qualify for visa-free admission must have passports that are valid for at least 6 months beyond their intended stay. The Philippine government intends to increase tourism by extending the visa waiver for covered nations from 21 to 30 days beginning July 1, 2013. It is according to the Bureau of Immigration. In order to expand the visa exemption to Chinese and Indian citizens, they propose that foreign nationals who do not require a visa may extend their stay for 2 months, each time up to a total of 2 years. For those foreign nationals who lack a visa may extend their stay by 1 month, each time up to a maximum of 6 months, and must have a valid ticket for onward travel. For replacement visas, those nationals of China traveling as tourists and holding a valid visa issued by Australia, Canada, Japan, United States, or Schengen area state may enter and stay without a visa for up to 7 days. And for those Indian nationals holding a valid tourist, business, or resident visa issued by Australia, Canada, Japan, Singapore, United Kingdom, United States, or Schengen area state may enter and stay without a visa for up to 14 days. They may enter from any port of entry. For electronic travel authorization, citizens of Taiwan may apply for an entry permit through the Electronic Travel Authorization System on the website of the Manila Economic and Cultural Office. There are also types of visas. The Philippine Immigration Act prescribes 14 different visas grouped into two broad categories, the Section 9 and the Section 13. Section 9 visas or the non-immigrant visas. This is for temporary visits, such as those for tourism, business, transit, study, or employment. And the Section 13 visas or the immigrant visas, this is for foreign nationals who wish to become a permanent resident in the Philippines. Some visas have been introduced by subsequent legislation or proclamation of the President, which are not classified by the Philippine Immigration Act as either being a Section 9 or Section 13. These visas are called special visas and are issued to groups such as retirees, investors, and entrepreneurs.